Good morning, everyone. My name is Graham Parham. I'm with Highlands Residential Mortgage. Today, we're going to talk about asset protection, and none better yet to have to discuss this matter would be Michael Savage, a good friend of mine. He's an attorney. He's at Savage Law Firm, and he has helped me many times over with my asset protection. And also joining me today is my production partner, Aaron Stelly. And we're going to talk to you a little bit about asset protection, the pluses, the minuses, and how we can help you, give you some peace of mind securing asset protection for your real estate holdings. I personally am an investor. I have gone through many different series of asset protection, going from LLCs, limited partnerships, creating LLC for individual properties, funneling into one master LLC, then funneling into a partnership. I mean, there's all kinds of ways you can slice and dice this. Other people have different views about asset protection, but in the real estate community, the LLC seems to be the most popular, which is called a limited liability corporation. And one of the things I want to talk about today is, some of the things you don't want to do, some of the mistakes you don't want to make, and I've made them. As an example, Michael, if you've got a guy in California that wants to create an LLC in Texas because his property's in Texas, what else does he have to do to get total protection? I believe he has to do a foreign agreement showing that he has to also establish an LLC in California. Am I correct on that? Help me out with that.
Well, no, California. So an LLC is formed. Every state has an LLC statute and has that form. That's been around for almost 30 years now, certainly more than 30 years. And so what the California resident would have to do, if they have a California LLC, then they would have to register that in the state of Texas. And I guess if the property is located in Texas, that would make sense because they'll be doing business in Texas. So they need to have a place that the Secretary of State knows in the state of Texas where they can be located. If a California resident says, "Hey, I want to create a Texas LLC," well, they can do so like any other Texas resident or any other, Tennessee resident. You just file it and have to have a place in Texas. It can be a corporate registered agent. It can be, any natural person. So there's really really no difference for a California resident to start a Texas LLC than a Texas resident.
Let's talk a little bit more about the registered agent, which means that they have to have an individual represented in Texas to be the registered agent. And they have to have their address. Is that correct?
Yes, you said individual. It has to be a person, and there's a difference in the law. A person can be an entity. So there are CT Corporation is probably the most popular. They are a corporate registered agent, so they will have a mailing address for you. So the purpose of a registered agent is really it's really a registered agent for the service of process. In other words, to be sued. So that's really what it is. They just need to be able to locate you in case someone in the state of Texas needs to sue you.
So in a lot of states, they have companies that are registered agents. You can hire a company to be a registered agent. They can facilitate a lot of the filings for you, if you will. They can do a lot of the legwork, if you will. But let's say, as an example, I've got properties in Alabama. I have a registered LLC in Texas, but I have to create that foreign agreement showing that I can do business in Alabama. Can you expand a little bit on that?
Yeah. Well, every state, I can't really address that from the standpoint of what's required in Alabama, because that's going to be Alabama law. But if it's just the reverse, that you had property, you were living in Alabama and you wanted to do something in the state of Texas, you would register register the LLC in the state, and therefore tell them and there's a fee, of course. I think it's $750. They charge you more if you're going outside coming in. But you just have to have the main purpose of it is to register so that they can know where to find you in case something happens. So typically, if your property's in Texas, you need to have some presence in Texas. If you same thing as if you're Alabama property, you have to have some sort of presence in Alabama. I'm sure they're going to require you to have a registered agent in the state of Alabama.
Okay. Aaron, do you have any questions? I know that you're about ready to start your own investment property in Oklahoma, of all places.
Yeah,
You thinking about doing an LLC?
yeah, I actually am kind of going through the steps of that right now. So this kind of introduction right here was very fascinating to me. Being for viewers out there, I'm located in Dallas and have a new build property coming up. It's going to be completed in Oklahoma. So Michael, take a complete newbie, so to speak, like me, and I'm looking at setting up an LLC so that, of course, my first property under my belt out in Oklahoma can have some protection. Living in Texas, would I want to set it up in Oklahoma or try to set it up in Texas? What would be kind of your recommendation, just from a big picture perspective, kind of getting started down that road?
Well, I think the easiest way, I think, for you, simplest way would be to set up a Texas LLC, assuming that's what you decide to do.
Sure.
You know, the question is LLC or no LLC. I think Graham and I have gone back and forth with this quite a bit in recent years. There's other entities. The default entity, I believe, is always going to be the LLC. It was created for just that, the small business owner. And so if you default to that, and you say, hey, well, listen, insurance, we talked about insurance. I'm sure Graham probably want to talk a little bit more about that, but you know, if you just want the protection that it gives you, since you're in Texas, I would recommend doing a Texas LLC, all things being equal, but I'd have to get a little bit more information. Are you going to plan to do more properties in Oklahoma? Because it gets more expensive if you're registering foreign entities in other jurisdictions.
Which is so what, $750 in Texas to add each one?
Right.
Yeah.
Correct. So you kind of want to get, I mean, every business plan changes from week to week, but you kind of want to get a ballpark or kind of idea where you're moving, where's your next property. And if you don't know, then yeah, I mean, maybe you just do it in Texas. It's easier. Your advisors might be in Texas, have a little more expertise. You don't have to go find a Oklahoma lawyer, Oklahoma financial advisor. So, that's probably what I would do first.
Okay.
Awesome.
The a lot of times people say, what's the best asset protection for me? Hey, I've got a family trust. Can I just use that? Okay. What's the benefit of having a family trust versus an LLC from the standpoint of protection?
Well, there really isn't a lot of difference from a standpoint of protection. There are differences from, taxation. There's differences in what your costs are, annual costs set up. Trusts, family trusts were originally kind of a very popular 10, 15 years ago. They still are, but they were really very popular because people were trying to avoid probate, and they were trying to figure out, okay, what happens when I die? I don't want my survivors to have to go through the onerous process of probate. Well, actually, probate isn't that onerous. Now, I say that since the pandemic, if you're living in Dallas County, it's become a little more, I say onerous, a little more time consuming. But most other jurisdictions, the issue is how fast you can get letters testamentary so you can act on behalf of the estate. It's usually pretty quick, usually 40 40, 45 days. Dallas County is a little bit different. So you got to know what kind of jurisdiction you're in. But for the most part, there are differences in tax rates for trusts versus an individual or a corporate entity. And then there's just annual costs from setting up and what costs you have. I mean, like an LLC has for your franchise taxes. There's a minimum. We can eventually go into that as well. But those usually are minimal. But you want to factor everything to the best of your ability.
So from a protection standpoint, asset protection, the trust is really designed for more of a probate and taxation versus the protection itself, correct?
Originally, but people have used it for asset protection. I mean, it is, any trust has a settler and a beneficiary and a trustee. The trust settler is who creates the trust, the trustee who manages the trust, and the beneficiaries are the people for whom the trust is set up for. To the extent, and this is kind of brings up some issues sometimes, and I've had this in my practice, where you have the trustee is also the beneficiary, or the person, the settler, is acting on behalf of the trust when he shouldn't. Then your liability protection is subject to being revoked, because you're no longer recognizing the distinctness of the entity. And it's kind of like, I think people have heard maybe piercing the corporate veil, which is kind of a thing you don't hear a lot anymore, where they're trying to look through the corporate entity, the protection of the corporate entity, and get to the individual. That's done more often than nowadays through trust. When if I'm going to set up a trust, and I don't want to give up control of that trust, well, I'm going to be subject to having that trust disregarded for asset protection purposes. And so that's the danger with the trusts, but can be used very often, and quite frankly, used quite a bit and very successfully.
I know a lot of organizations, companies, attorneys, and so forth really promote the LLC for severe asset protection. And I mean, it's been around, like you say, for 30 years. Another thing that I've run into sometimes, instead of people doing LLCs, they'll do land trust. Have you had a lot of exposure in land trust?
No, not really. I mean, I assume most land trusts are just a form of a trust. I don't have a lot of experience with that. I don't honestly don't see a lot of that in my practice from the more sophisticated investors.
Well, I'm going to outline what you and I have put together in the last several years. Is that I have LLCs on individual properties, and the LLC will actually funnel into my trust, where the trust owns the LLCs. Is that the ideal scenario from the standpoint of protection as well as probate, or what's your recommendation?
Well, yes, for protection, sure, because you have not only, when we've talked many times, you have insurance on your property, so that's one level of protection. You have your LLC, that's an additional level. Then it funnels into a trust, which is even a third level. That's about as protected as you can. But there are costs associated with each level, and so you kind of want to measure your costs versus your risks and your risk tolerance. And so, yes, to answer your question, that is very risk averse, but it's also very, as you know, can be somewhat more expensive than just setting up an LLC.
I know a lot of states around the country do charge to file your LLC report every year. Texas just happens to be one that they don't charge. And I think, as you say, there has to be a certain taxation threshold or under before they start charging or hitting you with some additional taxation. And in Texas, what is the threshold?
1.2, a little bit over 1.2 million.
Okay,
So your annual gross revenues are less than 1.2, then you're not going to pay any franchise tax.
okay. And actually filing franchise taxes, obviously you want your accountant to be involved with that because they're the guys that really understand it. I know a lot of people that can go onto the controller site and file their own taxes, but you really want to get an accountant to be involved with this. And I have to make this disclaimer. If you get an accountant and an attorney to agree on this topic, you're pretty successful. I'll agree. Michael, how many times have we been there?
We've been more than I'd like to remember.
So, you know, the attorney's aspect, they want to create protection. That's their goal, is to create the protection. The accountant is trying to say, okay, we want to streamline this process from an accounting standpoint. So you got to get them together. You really truly do, to make it work the best way possible. Now I'm trying to think on the expense. Let's talk about titling. So if you do a Fannie Mae loan, a 30-year fixed rate conventional loan, and I had this question asked every day, if I had $1 for every time I was asked this, I'd have a lot of money. They say, can I close the loan in my LLC? And the answer is no, and here's why. Fannie Mae and Freddie Mac, they issue personal loans, okay? And you're saying, well, it's a business. I'm creating a business. I know, but it's still a personal loan for an investment property. So when we underwrite the loan, we still look at the individual from their credit, their earnings, and their assets, okay? Now, there are other type of lenders out there that will do a thing called DSCR, which is debt service related type of underwrite, where they underwrite the property. In most cases, those entities or those companies that are doing the DSCR underwrite, they prefer to have you have an LLC, okay? So as an example, a lot of people that can't qualify for a loan in the Fannie Mae side because their debt to income ratio is out of whack, well, then they, at that point, go over to the DSCR, because on the DSCR lending, you take a look at their credit and you take a look at their asset and their experience as a landlord. That's it. And they underwrite the property to make sure the property's cash flowing properly to meet the DSCR requirements. Okay. Now, going back to the Fannie Mae scenario, okay, I want to close a loan, but you tell me I can't do it in LLC. So I'm going to close it in my individual name. Great. Well, can I transfer it post-close? Well, as a loan officer, I cannot tell you yes, okay? And simply because there's a thing on every Fannie Mae and Freddie Mae promissory note, there's a thing called due on sale. You talk to an attorney, you talk to a title representative, and some attorneys refuse to do it because of the due on sale. Some title companies refuse to do it, which means they refuse to transfer the entitlement of the property into the LLC. But 99% of my clients will do that same exercise. And I usually tell them, please wait as long as you can to do it, simply because when we close a loan, we deliver it out to the secondary market. It goes to Fannie Mae, and then Wall Street will buy it. And the individuals that are buying these notes, they're going to go through a due diligence process where they're going to re-underwrite the loan to make sure we did our job correctly. Once they're satisfied with how we did our job, then at that point they say, okay, we like the loan, we're going to buy the loan, we're going to set it up with this particular servicer, and off you go. So to let individuals know, and once again, as a loan officer, I can't advise you, but as an investor, this is what I know a lot of my investors will do, is what they'll do is they'll wait probably 4 months, get a couple of invoices from the new servicer on their belt. The dust is settled, the due diligence is over. They'll get their deed of trust, they'll get their LLC documents, and they'll send it to an attorney or a title closer and request that they, go ahead and put it into their LLC. And a lot of people say, a lot of people are going to say, is that going to trigger the due on sale? Well, I've been at this 25 years. I have never seen a due on sale called. If you stop making payment on your loan, they'll call it. But for the most part, they won't. And I'd like to share my screen just for a moment. And I got with my underwriting manager. And can you guys see that screen? Oh, I'll start again. You can?
Yep, we can see it.
Okay, can you see my mouse?
Yes.
Yep.
Okay. pretty straightforward. This is straight from Fannie Mae. To transfer the property to limited liability companies, provided that the mortgage was purchased or securitized by Fannie Mae on or after June of 2016. The LLC by the original borrower, or the original borrower owns the majority of the interest in the LLC, and if it's transferred, results in the permitted change of occupancy type to the investment property. Such change does not violate the security instrument, which means they have to hold on, they have to have it for 12 months. So let's just stop right there. As an example, some people will say, hey, I've had my primary residence for however long, and they want to go and do another primary residence, and they want to keep the current primary residence as an investment property. And at that point, they want to put it into an LLC. So this particular guideline here kind of states exactly what you can do, okay? Now, keep in mind, a lot of people that are doing these LLCs, that have these properties in LLCs down the road, let's say as an example, they do a property today at a higher interest rate because the market's up. And then say 6, 8, 10 months down the road, the market comes down because the recession kicks in, the rates come back down, they want to refinance it, but they've thrown it into their LLC. Well, when they do that, we come back to Fannie Mae or a lender, say, I want to refinance the note. Well, guess what? You got to take it back out of the LLC and you have to retitle it into your individual name, because Fannie Mae will not let you do it in an LLC. Okay. Mike, any comments on that?
No, I mean, that's actually great, great to know. That's, anytime you're taking out a loan and you're making certain representations, you always want to be very careful that those representations aren't true and to the best of your ability. So if you're taking out a loan and telling the lender, whoever that lender is, that these are the conditions upon which I'm borrowing money, I've seen it, and Graham, I'm sure you have too. Certainly in the early 90s, they were going after people on their mortgages for even then they were paid up. They were looking for reasons to go after people, but that seems to give you a safe harbor to do exactly that, transfer it from an individual to an LLC and back. So if that's truly from Fannie Mae, then yeah, geez, that's a great little opportunity.
So, and once again, as a loan officer, I'm not promoting this because, there is a dual sale on every note that we issue. Let's talk about the difference between a single member and a joint member. Are there any advantages, like a husband and wife or partners?
Yeah, husband and wife can kind of be treated like a single member. So when you talk about LLC, the IRS defaults a single member LLC. The default taxation regime is a disregarded entity. So all your income and expenses will go straight to your 1040. But a dual member would be, or more than one member other than your husband and wife. The default is to be treated as a pass-through entity. They're very similar. They're both ultimately going to come up on your 1040. When it's treated as a partnership, there is a return. There are K-1s issued that are eventually find its way to your tax return. I mean, it's a pass-through entity. It's just when I say it's a single member, when I say it's a disregarded entity, it doesn't mean it's disregarded for purposes of asset protection. It's just disregarded for tax purposes. So that's really the only difference. I mean, you can have a single member LLC be treated as a partnership. I don't know why you do that, but there are sometimes reasons. Yeah, as far as the two types of LLCs, the disregard entity is sometimes easier when you try to open up a new bank account with a single member LLC. They're going to ask you for an EIN number. Well, if you don't have employees, technically you're not supposed to have a EIN number. you're supposed to use your social security. That's your tax ID number. But when it's a multiple member LLC, you're required to have an LLC, and that's just for purposes of the IRS. So those are really the only differences, because that's the whole purpose of the LLC, is to create some form of pass-through entity, whether it's a partnership pass-through or whether it's a disregarded pass-through.
That opens up to another topic, and I want to talk about a series LLC in a second. Go ahead, Mike.
Well, hold on a second. So, and just when I say pass-through, when you have a corporation, and I'm not talking about subchapter S. So this kind of goes to the history of these entities. There was always a dual tax regime. So you get taxed at the corporate level, and then when you distribute dividends to the shareholders, they'd be taxed as ordinary income. So they created this subchapter S corporation. It had all sorts of limitations that weren't really conducive to some businesses. And then the states started coming out. I think it was Nevada, Delaware first came out with these LLCs many, many years ago. And it kind of had the best of both worlds. So you're only taxed at one level, which is the pass-through level, and you're taxed at your individual tax rate on both entities.
And I hear that a lot. Nevada's got this. I've got my LLC registered in Nevada or Delaware and so forth. If my customers are buying in multiple states, do you recommend them keeping their LLC in the state that they live in and do the foreign agreement, or do you recommend them doing an exchange in that, or doing the LLC in that state?
I would default and say you should do an LLC in the state in which you are located, and depending upon the costs associated with registering is that would be the determining factor. If you have multiple entities in multiple in say Alabama, well then maybe it makes sense to open up an LLC in Alabama and just have everything out there.
And I've faced those challenges with banks before on registering an LLC. Yeah, you got to give them all your corporate docs, your EIN number, and it's a little bit of a pain, but most banks will do it. I don't see of any banks that's ever kicked me out, not because of my entities, and it's always in good standing. I don't even think they do a deep dive on that. They just want to see the fact that you do have the numbers so they can plug and play. A series LLC. What's the benefit of doing a series LLC and having multiple properties funneling into one LLC?
Well, series LLC is really just a multiple LLCs that funnel into a single company agreement. In other words, you don't have to have documentation for each entity. There's really no magic about it. It's just kind of I have one document that shows how a company agreement that shows how I'm the internal operations of LLC number 1, LLC number 3, LLC number 12. So it's really just a means by which you can consolidate multiple LLCs in a single governing document.
Okay.
But still gives you same protections and same pass-through entity, same registration requirements, everything.
Let's talk about piercing the corporate veil. In my opinion, all of mine are single member LLCs. And if somebody wants to come after me, I had that one entity on, say, a property in Alabama, and somebody slips and falls, and they want to come after me, they're going to come after the LLC. And typically most attorneys will look at the registration of how it's titled and recognize that it's an LLC. And some attorneys will say, it's not worth me trying to go after. And some attorneys say, we can pierce that, okay? Because from what I understand, even though the LLC, they're coming after the LLC, well, I'm the owner of the LLC. So my protection, where does it kind of start and stop?
Yeah, that's a tough one. I deal with that almost every day in my practice, where someone's being sued and they come to me and say, well, my business is being sued, but they brought me in. And that's sometimes just sloppy lawyering. It's sometimes lawyers who just trying to get to intimidate. for the most part, it's very difficult to pierce the corporate veil. And we say corporate veil, it's not really truly a corporation, but it's the old before LLCs. That was the way to try to do it. It was to try to get to the individual members, as opposed to, an LLC may have one asset. Sometimes it has no assets. It's just a service business of some sort, and they want to be able to attack the individual, and there's nothing to be gained in that LLC because there's no assets. Different than what we're talking about here, which is, investment properties. But people are going to try to, basically bring as many defendants in as possible, because those are different possible people who might be able to pay them. But it's very difficult. And typically, the hallmark of a true piercing or looking beyond the corporate veil or the LLC limited liability protection is fraud. If they can show that you've committed some sort of fraud, in the end, fraud being using the entity as a agent of fraud, typically, and I'm really referring to Texas law. That's usually when they can pierce the corporate veil. It used to be that you were not having regular meetings. Well, LLC kind of did away with that. Said you don't really have to have, don't have that formalized. They don't have to have all the formalities like a board of directors. The board of directors would have a meetings to open up a bank account, to do X, Y, and Z. LLCs kind of did away with that. But even before it went away with that, there was some case law and now some Texas laws that have been put on the books that basically say, listen, unless you're using the entity to perpetrate a fraud, we're going to honor the entity. That doesn't mean you're not going to have to face personal lawsuit against you, but your lawyer should be able to advise you as to what your liability, if any, is. Usually it's not much. And there are laws, there are certain laws, like in the construction business, that somehow try to figure out ways to pierce the corporate veil, but those are very few and far between.
Which leads me to my next topic. Once again, I get this topic all the time, and I tell them, what is my peace of mind? What do I do to protect myself? Let's say I have my LLCs, and as you say, somebody wants to get ornery and they want to come after me and they want to try to pierce that corporate veil. Well, guess what? I've got to hire you to defend me. Okay, that's going to cost me. Okay, so what I do, and a lot of people should do this regardless if they have investment properties, is to get an umbrella policy. An umbrella policy can be very inexpensive. It can cover your personal liabilities, your home, cars, your property that you live in, all kinds of different things, but also it protects any investment properties that you have. So what I do is I have about a $5 million policy because I have so many properties to help me protect in case somebody does want to come after me, because I have to pay Mike to defend me in court. Well, I just make a claim on my umbrella policy. And if you make sure when you look at these umbrella policies, they have adequate attorney protection. Because it could add up quite quickly in the court and the attorney fees. So the asset protection is great, but you still want to have something as a backup to help defend you in case somebody does come after you. Once again, the umbrella policies are very expensive. I highly recommend. Any comments on that, Mike?
Yeah, yes, exactly. I think that's one of the first choices. And sometimes you look at it and say, well, I'm comfortable with my insurance. Do I really need to have further asset protection? An LLC, I've always said, is a really cheap form of secondary insurance, because it's another layer of protection between you and your personal assets, or between your multiple business assets. But so yeah, the problem with insurance companies don't like to pay claims. There's some very good insurance companies that do. None of them like to it, but they will honor it because it's a contract. So to the extent you've read your policy and you're comfortable with the policy, and that you believe that your set of risks are within that policy coverage, then that's essential. And then, as far as asset protection, all the things you can do is the insurance is one. We talked about the LLC a little bit, but also is your lease. You got to make sure your lease is pretty solid, because that's usually, if you're an investment property, your main liability is usually going to rise out of your lease. And so if you can tighten up your leases as much as you can, that will also provide a different level or another level of protection.
That's interesting. Can you elaborate a little bit further on that? Because I never really pay attention to the leases, because I trust most of the management companies that I have that know this information, and they create these leases to address these situations. Have you heard of anything that you can share with us that it didn't?
Well, nothing comes off. Well, you're usually doing a lease to protect your investment, your stream of your income. With the COVID, there's the whole thing about what is the force majeure, which is an act of God, and relieving certain obligations pursuant to a lease. But really, what you really want to do is make sure that your tenant is using that property in a manner that's consistent with what you believe they should be. Like, you don't want them to be having a business there. You don't want them to be, maybe you do, maybe you don't, depending upon what kind of lease. If it's a commercial, then obviously you do want them to be doing business there. But if it's just a residential, you need to be able to define in your lease what you expect your tenant to do and not to do. Therefore, if they are doing something contrary and doing some dangerous activities or anything that's not consistent with the lease, well, then they're in breach of the lease, and that would alleviate any expectation that you would have that they'd be doing something otherwise. So it would also limit your liability from that standpoint. Just tightening it up, making sure that the use that's in the lease specifically addresses what you think they're supposed to be doing and exclude all other things.
That's great information. I love doing these webinars, because I always learn something on there. Aaron, obviously you learned something today as well as myself. You have any questions for Mike?
Yeah, this has been great, Mike. So appreciate you taking the time.
Sure.
Kind of a tricky question, but from this call I've gathered, there's so many pros to getting that asset protection LLC or other ways. I'm curious, any cons that kind of stand out to you, maybe off the top of the head. We of course went over the due on sale clause, which is kind of totally workable as long as you plan for it. You went over costs and somehow and explained how prepare yourself for those costs if you are setting up multiple LLCs, different states, anything like that. Any other kind of cons whenever we're talking pros, cons, any negatives when it comes to LLC that are kind of important to note while we're on the topic?
Well, not really. I think once you explore the costs and you weigh those against what your perceived risks are, and again, it really depends upon, who's your tenant, what you're planning on doing. If you're flipping houses, all those kinds of things. It really just comes down to the cost, and there's also traditionally real estate was done in limited partnerships, and there was reason for that. It was one, to create a protected entity, asset protection, but it was also to centralize management. So an LLC, it's really not a centralized management regime unless you have managers, and even then, most people allow members of an LLC to act on behalf of the company. So those are can be issues that are and so what happens was, these limited partnerships would go out and raise money, and these limited partners by law can't have any management control, otherwise they would revoke the limited liability nature of the limited partnership. That's not the case in an LLC. So that would be a negative, but it's not a significant negative. And there's ways to draft around that, if you will. But if you're going to have 5 or 6 guys of differing, agendas, if you will, LLC may not be your way to go. If it's just you, then I think it's really mostly an issue of costs, how many you're going to have, what state you're going to be in. Those are really, and how good you have, how good you feel about the level of insurance you have.
Awesome. You can work in several states, is that correct?
Yes. Well, no, I'm licensed to practice law in the state of Texas and the state of Massachusetts.
Okay. Can you help people that want to set up LLCs in other states, or should they go to an attorney in that state?
They should probably go to an attorney in that state. Well, they definitely should go through an attorney in that state, and preferably not a CPA, because sometimes CPAs try to set those things up. They're great at doing certain things, but when it comes to some liability issues, like Graham said, there's the issue of liability and there's the issue of counting. But I would seek counsel from like an Oklahoma lawyer if you're trying to set something up in Oklahoma.
If anybody does have some interest of setting up LLCs in Texas, Mike, what's the best way to get a hold of you?
Well, the best way to get a hold of me is at our office here in Dallas. It's at 8226 Douglas Avenue. And the phone number is 214-346-4200. You can ask for me or my assistant, Joanna, and they'd be more than happy to help you.
Guys, I've been working with Michael for years. He's an extremely excellent attorney. He's not like most attorneys. He's more than willing to help you out. He cares, and I really respect that. So if you need any assistance in assistance with Dallas or Texas or Houston or wherever, give them a call. But I really appreciate you guys today sticking in and listening to us. So hopefully this will benefit you. And if you're listening through this on YouTube, there's a subscribe button at the bottom. Please do hit that. And if you need to get in touch with us and you want to pick my brain a little bit more about the LLCs and how it reflects on me personally, you're welcome to give me a call at 855-326-6802. Thanks, guys. Have a great day.
Thank you.
Thanks, guys.